welcome to Canton Community Television. My name is Tanya Willow, and this is a Canton Community Television special on planning for elder law. And with me is Roger Levine, who's an expert in that topic, an attorney. Thank you, Roger. This is part 2 of the program. We did something and talked a bit extensively on planning and protecting your home in case you go into nursing home care.
Nursing home stuff, yeah.
Yeah, but because this is a big topic, we thought we'd talk about some other elements involved in it as well, Roger. And one of the things you want to talk about is, I don't know what the terms are, but the paperwork that's the most important, which includes wills and durable power of attorney and all that type of thing.
Okay.
Let's talk about the difficulty in having to get this paperwork in order. What are the big things we need to take care of?
Basically, I call it what I call core estate planning. We talked about a little bit about this last program, but they're the basic core legal documents that pre-speak anything situation that'll come up if you either pass away or you become legally disabled for health or financial purposes. And people generally think in terms of a will, and a will is certainly a core document there. But there's basically 5 core documents in Massachusetts. 2 of which are financially based, 3 of which are medically based. 2 that are financially based are wills. When I die, this is how I want my stuff to go. This is where I want to get it. This is where I don't want to get it. A lot of times trusts go in conjunction with wills. Trusts in particular are used for avoidance of probate, which we'll talk about a little bit later. They can be beneficial for doubling what you can leave estate tax free, which I think we're going to talk about a little bit later. So wills and trusts sort of go together. There's what I call core disability documents. If a person becomes what's called legally disabled, for financial purposes, for example, somebody else just can't automatically make decisions for them. Assets are generally held by a third party, whether it be a registry, a bank, an insurance company. So if your husband becomes legally incompetent, you just can't necessarily sign for him. When somebody's legally incompetent, you have to go through a court process to become a guardian. All right? There are documents designed to avoid having to get a guardianship if a person becomes legally incompetent. In particular, a durable power of attorney basically says, hey, if I'm legally incompetent, I appoint my husband and wife to be my agent, or I appoint my son as my alternate, or I appoint my son as my main, so that if you become legally incompetent through time, age, accident, whatever, then that family member, the family doesn't have to go through the court process of getting a guardianship, which is an ordeal.
Roger, not to interrupt you on this, but we talked a lot about house planning in case you go into a nursing home, but as you're speaking, I'm thinking, my goodness, these aren't just documents that you should get as you age. These might be something we all should have.
Well, I mean, basically, in my opinion, core estate planning starts when you have something to lose. If you pass away, you become legally disabled. Now, theoretically, if you have real estate and or children, you have something to lose. If you pass away, you become legally disabled. So a lot of times, I think of it as sort of like legal insurance, like you have life insurance if you have children.
This stuff doesn't automatically go to your spouse if you're married, in the guardianship and all that. The court doesn't look at a marriage as an automated system then, as far as all that goes.
No,
just so we're clear about that.
Not at all. So, yeah, I mean, core estate planning to me starts when you have something to lose. If you pass away, you're legally disabled.
Why would you prefer, just based on what you said, of going over these 5 documents, 2 of which are financial, if we talk about the 2 financial first, will and trusts, it sounds like trusts are much better than wills. Why would you ever go with a will if a trust seems better? Just as a layman listening to you talk about the 2 of them.
Well, they're sort of 2 different things. I mean, a will is specifically designed, and this we'll mix in probate here, okay? Because there's no way I can answer this question without talking about probate.
Sure.
All right. Basically, a will speaks for anything that somebody dies with in their name alone. All right. That's the key concept. Anything that somebody dies with in their name alone legally has to get to who or what they want it to get to. Okay. In reality, a lot of times assets pass apart from a will. If you have joint ownership, an asset will go to the joint surviving owner. If you have something with a named beneficiary, such as a life insurance policy, an IRA, once again, it doesn't touch a will or a trust, it passes to the named beneficiary, which is a whole other area. People, don't even get me started on that.
Sure.
Should I? I should mention this.
Sure.
Since a lot of assets do pass to named beneficiaries, people should be sure to review all policies every 3 to 5 years to make sure that the named beneficiary that you have is still alive, number one, and number two is still the person or the people that you want. Because a lot of times what happens is the beneficiary has died, so my life insurance says it goes to my wife, but my wife is not living. Guess what? It goes to your probate estate.
Sure.
All right, or it goes to my IRA goes to my son. Well, my son hasn't talked to me for 30 years. Guess what? That IRA is going to your son. All right, but a lot of times assets don't pass by a will. They pass by those methods. All right, but if you have assets that are in your name alone, say husband and a wife have a house, the husband dies, the house is in the wife's name alone, then the wife dies, that will pass by the will. All right, that's a probate asset. And if the will says, you know, I want it divided equally between my 3 kids, that's how it's going to go, even though it has to go through a court process.
Just to interrupt you, Roger. I always hear you try to avoid probate, but I'm not clear what it is. I just think it was once described to me. It's a it costs $10,000 to have a judge make a simple signature. What is probate?
What is probate?
Yeah.
I don't remember. No, just kidding. In 25 words or less, probate really is a process of anything that somebody dies with in their name alone has to legally get to whoever or whatever they want it to get to.
Is it done in a hearing? I mean, how is that done?
It's a court process.
It
It's
is,
through
yeah.
petitions, and sometimes there's an appearance or a couple of appearances before a judge. But basically the key concept is anything somebody dies with in their name alone. And it's not whether you have a will or don't have a will. Because if you die with an asset in your name alone and you don't have a will, you still go through probate. It's just that you have what's called an intestate distribution, which means it passes by a state formula. So it's certainly always better to have a will than not have a will, but the key concept is anything somebody dies with in their name alone. You asked me about trusts. All right. Trusts are basically documents that go with wills. All right. Now, one way that trusts avoid probate anything that somebody dies with in their name alone. Say you have a single individual, has a house in her name alone. When that person dies, assets in her name alone goes through probate. Now, if that person were to deed the house into a trust, literally, I, Mary Smith, deed it to the Mary Smith Trust, and that deed gets recorded at the Registry of Deeds, well, when Mary Smith dies, there's no probate. Why not? It's not in her name alone because it's in the name of the trust.
I get
Okay,
you.
so trusts
okay.
can avoid probate because the asset's not in your name because it's in the trust's name.
Okay.
Okay, so that's how wills and trusts sort of
is then
differ.
the trust redirected to whomever it is you want to actually get the house?
Yeah, the trust becomes what's called a distributing instrument. Usually when you have a trust, you have a will also. The will's called a pour over will. The will basically says, hey, whatever's not in my trust, put in my trust and distribute from my trust.
Okay.
Okay, so that's how they sort of differ.
Okay.
Durable power, we talked a little bit about pre-appointment of somebody to make financial
Well,
decisions.
just to get back to this piece, because it went right by me, so I'm sure it went right by our audiences too. Phew. So I have a will that sort of works together, maybe best to have both, it sounds like, to have a trust.
Not necessarily.
Oh, really? No.
I mean,
Yeah.
trusts, it depends on whether your situation calls for it or not.
Well, this other piece, going to probate, sounds terribly expensive to me. So that
Not
sounds,
necessarily
oh, really?
expensive.
Oh,
I mean,
really?
there are filing fees to the court, which tend to run between, say, $250 to $500. There's a publication fee in a newspaper.
But a lawyer's going to do all this for you, don't they? So that's
Well, once again,
lawyers are expensive, Roger.
just like the Your Honor, just like the Medicaid application.
Sure.
The lawyer doesn't have to do a probate for you. I think
But you
you're-
prefer
I
they
think-
would. I
you're
would think
better
it's smart.
served
Sure, I
because it's
think
an
so,
unfamiliar
too.
area for
Right.
most people.
Right. So if I set up ahead of time, if I set the trust up ahead of time, wouldn't the lawyer time be less on the other side?
Usually,
Okay.
usually the cost of a trust is less than the cost of probate.
Sure. Sure.
But once again, it's not etched in stone.
Okay.
So
Okay. So I'm just thinking that would probably be, from a layman's perspective, maybe not a bad way to go, to put things in a trust with a will, and then.
well, I mean,
That way.
basically, everybody's situation is different. What I
Okay.
try to do, and I think what any good elder law attorney will do, is they'll try to get an idea of what a person's hoping to clarify or achieve. In my particular case, and I think a lot of lawyers do this, is there's a checklist you'd walk the person through to find out what their family situation is, what their asset situation is, and sort of tie it together. Well, since you're looking to achieve this, this is what I recommend. Certain situations...
So you know the best tool for that particular family situation.
I mean, certain situations do lend itself more so to wills and trusts. Certain situations, in my opinion, can be handled by wills alone.
Okay. All right. Now, then there's the health element involved here. We talked about living wills, healthcare proxies, and HIPAA.
Right.
Now, what are those and how are they all related?
Well, those are 3 health-related documents. Once again, they're disability documents, but instead of for financial concerns, they're for health concerns. Once again, if a person is legally incapacitated and can't make health care decisions for himself, whether it be a husband for a wife...
And this is, again, not automated just because you're married?
Absolutely not.
Okay.
All right.
I kind of thought that for some reason.
No, it's not.
Okay.
It's not the case at all.
All righty.
That...
So if I'm lying there in deep trouble, if I didn't do this, my husband can't make those decisions for me? If I don't have these documents?
He can do it, but he'd have to go get a guardianship. He'd have to go through the guardianship.
We talked about that in the last program. That's a nightmare.
It's a nightmare.
Okay, so let's talk about these horrid documents, then maybe we should all get them done. Go ahead.
Well, I mean, they're basically fairly simple.
Are they?
I mean,
Okay.
healthcare proxy is a legal appointment of an agent to make healthcare decisions should you not be able to make them yourself. Usually we have an agent and we have an alternate agent in case the agent isn't around. They're with us any longer.
Sure.
Sometimes we have co-agents, but that's what that's about. As we said, I think in the earlier program, the document that goes with the healthcare proxy is called a living will. And even though there's no statute about the living will on the Massachusetts book, it's still a valid document. What the living will is basically a statement from you yourself that says, hey, if I'm vegetative, comatose, no chance of recovery, that I wouldn't want to be kept alive in those circumstances.
Just to interrupt that a little bit, Roger, who would? So why is that in dispute? I never understood that. If I'm in a, I don't know anybody who says, oh, if I'm in a vegetated state, I want to be there. Why is that so important to emphasize? Who wouldn't
Well,
want
because
to be
the
in that
hospital
state?
can say, we don't know what the person's wishes are. Maybe the person does want to be kept alive. As to be very cynical about it, not that I would be cynical, hospital being reimbursed by Medicare money, a lot of times they have incentive to keep somebody alive. So I would say most people wouldn't want to be kept alive as a vegetable, which is what we're talking about here. But without a definitive statement from a person, we don't know that. Hospital may be afraid that they might get sued. There might be the aforementioned, hey, you know, they're making money on the situation.
Or there might be some outside hope of them recovering from this horrific situation.
Well, usually these things are tied into, and once again, I'm not a doctor, medical standards. I think it's 2 flat line encephalographs, brain dead. So, I mean, it's usually like, hey, they're not going to recover.
Sure.
So that goes with a healthcare proxy. I brought up briefly that whole Terry Schiavo case on the last program we did. And what that was all about is she had a healthcare proxy naming the husband, but she had no living will. So the medical institution says, we see you're the agent, but where does it say this is what she wants to do? And that's why...
But isn't that what the point of the agent is? The agent speaks for them? What if there's a circumstance that's not specifically in
the agent is supposed to speak for them, but a lot of times without the direct, clear language of saying, hey, don't keep me on these machines, the hospital is hesitant to do it for whatever reason.
Okay.
Okay. And I think we talked about last program, the
HIPAA?
The HIPAA, which is something that's relatively new as far as these things go. Because of the rise of the internet and concern about privacy of medical records, the federal government passed something called HIPAA in 2003, Health Insurance Portability and Privacy Act, which now medical institutions are hesitant to give records to agents because they're afraid they're going to violate these HIPAA provisions. So we do a HIPAA release that says, hey, you know what, if my agent needs access to my records, I'm aware of HIPAA, and I'm authorizing him or her to have access to those records.
So in other words, it would be very difficult for a person to make medical decisions based on your best interests without having all the medical information necessary to help them make that decision.
Well, number one, it would be difficult, and number two, it wouldn't be legal. They wouldn't be allowed to do it because they don't have the catch-22. They don't have the documents.
I see. Interesting. So they all kind of marry and go together.
Yeah.
So these are documents, I don't know, Roger, it sounds like they're documents that maybe all of us need, not just the elderly, but all of us need to maybe think about if
I would think once again, it's not just for older people. I mean, it's for anybody who has children or property, or both, but certainly the older you get, I would think the more important they get.
Now, we talked a little bit about probate and estate taxes. How does that all come into play? And is there any relation to this, that famous death tax they talked about 100 years ago? I know that from what I could understand, for the average everyday person, we wouldn't even come close to such